we've come to the very last part of our little chronological examination of what happens to someone going through the criminal justice system. We had the criminal investigation process, we had the criminal trial process, we had the sentencing process, and now we're going to look at post-sentencing considerations, so after sentencing. And we need to examine the implications of post-sentencing considerations in achieving justice. Now, I said that very quickly, kind of glossing over it, but we need to look at it in a bit more detail, what it means before we really start. So to examine means to inquire into, which again is stupid, because no one really knows what inquire with an I, inquire into means. It means we've got to look at these things closely, and we've got to look at some of the questions about it. So remember, we're asking some questions, we're writing some possible answers to try and examine, but the red box at the top says examine the implications of post-sentencing considerations in achieving justice. So oh man, I hate these syllabuses. I hate these syllabuses so much. They take things that should be fairly straightforward and make them very, very difficult for anyone who doesn't have an immediate grasp of English, which really shouldn't be the focus here. It should be whether you can understand the law rather than do I understand the syllabus. So implications means consequences. Right? So we're going to look at what the consequences are of some of these decisions we're going to look at, and whether they're really achieving justice. So, for example, we're going to look at continued detention, which is where offenders are kept in prison after their whole sentence. And we're going to ask, is that a good way of achieving justice? And for whom? Like the person obviously isn't going to achieve justice. What about for society? What about for the victim? So we're going to look at the decisions that get made after your sentencing decision, and what the consequences of those decisions are, and whether those decisions are achieving justice. So some of these issues we're going to find don't really have big justice questions. So let's say security classification. Arguably you could go into heaps of detail. But when someone has committed a violent crime, they have a higher security classification, and they have to go to maybe a maximum security prison. Now that really isn't going to. That's not really iffy, like a grey area. You're not going to go, well, actually, I think they should go into a lower security prison. That's not going to be the justice issue that we're going to look at. So we're going to look more at things like parole, and preventative or continued detention. We're going to look at those things because they have some significant issues when it comes to achieving justice. So let's go through what they are. Post-sentencing considerations. After the defendant has been sentenced, there are still more issues that might need to be decided on. But you have to know that this is not in every single case, right? So don't think that all of these, the idea of deportation, some people think, oh, okay, well, you go through the whole process and you go to jail and then you get deported. Well, if you're an Australian citizen, you're not getting deported, are you? So it's only in some cases. In some cases, some of these are, say security classification is not in every case, so only really if they're going to jail. Protective custody is only in certain situations. So it's only for some cases, each of these, not all of them. So let's do a little timeline. Let's say you're found guilty, you're sentenced to imprisonment. So let's assume that. Now, there's a period, often before your incarceration, where they have to work out, okay, which prison are you going to go to, what's your security classification and all that. Then you've got the red zone. This is your non-parole period. This is where you are in jail. You are not getting out unless you've got a spoon and a poster you can hide the hole that you're digging behind. You are going to stay in jail. And that non-parole period might involve some protective custody. So for all or part of your sentence, you're going to you might have to have protective custody. So say, for example, you're a former police officer or something, and if people find out, they're going to do all sorts of nasty things to you, so you might need to be protected there. Now, after that non-parole period, parole is possible. It's not guaranteed, but it becomes possible, right? So we've got this, yellow going into green box there, where parole is possible. It gets, more likely the later you go. So it's not, as likely on the day you're available to get parole, or you're eligible to get parole. But as you get closer to the end of your sentence, it goes green, because you're more likely to get parole. So from there, parole, that's another consideration we're looking at, might be possible. When you're released, whenever you're released within that, and it might be at the start or at the end of that period where parole is possible, non-citizens who have been in Australia less than 10 years and they've got 12 months or 24 months or 10 years or 20 years in jail, deportation is the consideration we're going to look at. If you are a sex offender, so you're a serious sex offender, then you obviously that's going to be the consideration that will need to be dealt with. You don't need to be registered as a sex offender, I guess, like while you're in prison, because you're not around. I hope you're not around a lot of kids, but you will need to do it when you go back out into the community. Now, after you've served your sentence, so you've got this green arrow, and it's a little bit iffy whether that actually exists now, because we have this preventative or continued detention, which is more and more of an issue. So you might have to actually stay after the green point, after the parole possible, after you served your entire sentence. So you can see on the top and the bottom, you can see all of these areas that we're about to look at, and they go in sort of order, except for preventative and continued detention. It really depends on what the particular case is. But you understand, as long as you understand that these are not going to be issues in every single case. So let's start with the most basic one, the quickest one. Security classification. Once you've been found guilty and you're going to prison, we need to work out where we're going to send you to prison. And there's over 30 prisons in New South Wales alone, and I'd be stunned if you could name more than 5. So we've got 10,000 or 11,000, depending on what day it is, prisoners. And we have a Department of Corrective Services who makes that decision about where the person is going to, serve his sentence. And so each prisoner gets a category for their security classification. If you're at Category A, then that means you're dangerous. C is the least serious. E are the escape risks, who are obviously going to need to go to a higher security prison if they've tried escaping before, or if they have significant organised crime links and things like that, that they might be an escape risk, and that helps decide which prison they're going to go to. Because if you're Category A, there's only a certain number of prisons that have Category A facilities there, like maximum security prisons. So they need to make the decision according to that. And there's even a prison at Goulburn, the Super Max prison, which is super maximum security, which is for like serial killers and gang leaders and stuff like that. And if you're a freak out there, probably 7 or 8 years ago, there was a Four Corners episode about the Super Max prison, and you could probably look it up as well. It's mainly just putting it there so the markers go, oh, you've been watching Four Corners, oh, I like the ABC too, and then give you good marks. So you've got Four Corners, an episode about Supermax, but there might actually be something even more recent, so you can Google it and then just freak out at how much like a hospital these super maximum securities prisons look. The second thing is protected custody. Now, this is a little bit more controversial. Some prisoners are put in separate areas of the prison, or they move to another prison, usually because their lives are in danger. So if they're a rat, if they're an informant, their lives are going to be in danger in the prison when people find that out. If they're in prison for child sex offences, they're also going to be in a lot of danger, because other prisoners, they have this, they still have this sense of morality that we are animals, but they deserve to have every bad thing happen to them. So we're going to take it all out on them. At least we have some sense of right and wrong. I just robbed a convenience store or something like that, but this person's a pedophile, so a rock spider or whatever they want to call them. So we're gonna do bad things to them. And this is what happened to the former Deputy DPP of New South Wales, Patrick Power. Patrick Power was like the second in charge prosecutor, and it turned out that he had child pornography. He got 15 months in prison, but get this, he only served 8 months. And the reason that was given for him being released early was that he was in protective custody the whole time. Like, why was he in protective custody? Well, first of all, like, child pornography is not something you want to be found out that you're in prison for. But because he was in charge of, putting some of those people in jail, they would have done all sorts of horrible things to him. Right? So he was locked up by himself, all alone, away from everyone else. And his sentence got cut almost in half. And that's very strange. Being isolated from prisoners is apparently worse than being locked in there with them. I would prefer every single time. I would prefer protective custody. If I was going to jail and I knew that I had to go to jail, I would do everything I could to get myself put into protective custody, right? Because I don't want to be friends with the rest of the prisoners, because I wouldn't be friends. I'd be currency, right? I wouldn't handle that. So there's been this general presumption in the past, since the Gilchrist case in 1991, that apparently it's harder to do time by yourself. I don't think it's harder to do time by yourself, but now they've kind of worked this out. Now, for example, say you were a police informant, you dobbed on your friends to the police, you used to get a discount for providing that information, and then you get put all by yourself in the prison, and then you'll get an extra discount for being all by yourself in prison. And the former New South Wales Attorney General, John Hatzidakis, he said, okay, judges, when they're sentencing, they're just going to have to acknowledge that prisons are now a safer place. And so we're not going to do this anymore. We're not going to, have this automatic assumption that, everyone is going to have a harder time if they're in protective custody. The Liberal Party at the time, they said, New South Wales Labor was just trying to be tough, because it was just before the 2010 election. Justice Action, they represent the rights of people who have been, of criminals, really. They say, look, these prisoners get locked away sometimes 23 hours a day from everything. So being in a cell 23 hours a day, it will drive you crazy, and spending more time there or spending your entire sentence there is incredibly difficult. I mean, for me, it would be incredibly difficult, but still preferred. So now, since 2010, prisoners in New South Wales have to prove that they will face tougher conditions than the other inmates before they get a sentence discount for that extra hardship that might come from being stuck in protective custody. So if you, if I were to be in that situation, I would have to prove that being in protective custody is actually worse for me if I wanted a sentence discount, and I wouldn't be able to prove that, because it would be very obvious that not being in protective custody wouldn't be worse for me. It would be much nicer for me to be in there. The third thing is parole. If you get parole, you get released from prison, and people say, "Oh, you get released early." Well, yes and no. I mean, you get released from prison, but you get these conditions, right? Technically, you are still serving your jail term. So if you get 10 years in jail and you get paroled after 8 years, those last 2 years, you are actually still serving your sentence, right? You're just getting released, to get you used to the community, used to being back in the community, but you can be taken back to prison, right? You are still serving your sentence. The decision to grant parole is made by a group of people called the Parole Board. They look at things like, have they been a good boy while they've been in prison? Is it really in the interest of the community for this guy to be out? And how well the inmate will reintegrate into society. So the longer you've been in prison, the more difficult it's going to be for you to be able to reintegrate into society. Now, contrary to what you would think is logical, the Bureau of Crime Statistics found that when people are released on parole, they're actually more likely to be reconvicted than people who don't have supervision. So if I got 10 years in jail and I served the whole 10 years, I would be less likely to recommit a crime than someone who got out after 8 years, spent 2 years getting monitored and checked up on and treated like a criminal, like I'm still in jail. Then I would be less likely to commit a crime than that person, and that's counterintuitive. I mean, you wouldn't think that that's true. But it is. I trust the Bureau of Crime Statistics. I don't think they lie to me. There have been some big, semi-recent parole cases. The Lim case, Chunti Lim, and Chu Seng Lu. These were the guys who killed Dr. Victor Chang. The first one was just the other guy, not the guy who shot him, and Chu Seng Lu was the guy who shot him, and so he ended up with 2 more years. Which is in itself is very, very strange that they got similar sentences, but it doesn't matter. So when their decision to be paroled was made, it was very controversial, because they were saying, wait, you can't just kill Dr. Victor Chang and then ever get paroled. You should fulfill your entire sentence and be kept even longer. because you can't kill Dr. Victor Chang. He was like the Australian of the century. You can't kill him. But if you want to kill someone else, like, just a mother of 3 or something like that, that's okay. The government's not going to freak out about your parole decision, but we will if it's a public thing, and you did good things during your life that happen to help a large number of people. Your life is worth a lot more than, like I said, like a mother with children or whatever. So the government freaked out about it. They resisted. They challenged these decisions. The parole board actually reversed their decision in the first case, and then it was appealed. And there was really no reason for them to reverse their decision other than they didn't want to be unpopular, which isn't a very good reason. But the parole decision should be based on the offender, not what the victim happened to be. It should be based on, is this person, the things that were originally getting looked at. Have they been good in prison? Is it in the interest of the community for this person to not have to cost us, thousands and thousands of dollars a year to keep them in prison? Will they reintegrate into the society? Well, these guys ended up getting deported, so there wasn't a question of whether they'd reintegrate into society because we were getting rid of them. So getting them on the first plane back home, it seemed like a good idea to me. But the system itself might be changing. In 2013, again, the New South Wales Attorney General said to the Law Reform Commission, I want you to look at our parole system in New South Wales. So the same as like the criminal appeals, they got 4 jobs on one day, 4 giant jobs on one day. The Attorney General just had a I don't know, he just decided, okay, I just want to do all this right now. I want to change the law, so I'm going to send 4 things to the Law Reform Commission, and I guess they do it in whatever order they can. So like the Criminal Appeals Report, the parole report probably won't be released until the end of 2014. But just keep checking the Facebook page. Maybe you'll be able to see, before the 2013 or 14 exams that it might have changed. And after that, well, you're probably not going to be listening to this anyway, but you should check and see that this system will have changed somehow. The government will probably respond, end of 2014, or sometime in 2015. Preventative detention. Now, this presents a terminology problem. There are 2 types of preventative detention. The first one is if you arrest someone and keep them without charging them with a crime. So if you just picture an Arab in your head and think of arresting them without charging with a crime, but then keeping them in the police station and waterboarding the shit out of them. No, not doing that. But yeah, you could imagine that is preventative detention. We think you are a terrorist. We think you are going to blow something up. So we are going to keep you in jail for up to 14 days to make sure that nothing happens, right? That you can't contact all your terrorist buddies. The second type of what is often called preventative detention is keeping an offender after their sentence is finished. Now, what section are we in the syllabus? We're in the section about post-sentencing considerations. So that first one, that first preventative detention, that would probably belong way back in the criminal investigation process. We're looking at post-sentencing considerations, after someone has been sentenced. Now, the first one doesn't make any sense to have here because it has nothing to do with after someone's been sentenced. The first one is about them not even being charged yet. So why is it in this part of the syllabus? The second one is what we're looking at here. Right? I assume, because this is the post-sentencing consideration. We're looking at after someone has served their entire sentence, can we keep them in prison? And yes, we can. So, the terminology solution is that let's not call it preventative detention, right? If someone's held after they've served their sentence, we'll just say that second type of preventative detention is called continued detention. So let's skip number 4 completely. So look down that list, 1, 2, 3, 4, preventative detention. Let's skip it completely. If you get a question about it, and it's about post-sentencing considerations, then just write about continued detention, because that is a post-sentencing consideration. Preventative detention isn't. So continued detention. That lovely man right there is someone that caused a lot of controversy in New South Wales. But you wouldn't have been aware of it because it was probably when you were born or before you were born. This idea of keeping prisoners in prison after they've served their sentence, it seems very, very convenient for us. We wouldn't like it happening to us. We would hope that if we got 1 year in jail, that we would serve no more, not 1 hour more than that year. So we wouldn't like it being done to us, but we seem fairly happy to do it to other people for different reasons. So we're going to look at some major cases and some major legislation that's happened. So that guy there is Gregory Wayne Cable. Cable stabbed his wife. There was a custody dispute. They were in the kitchen. He stabbed his wife, killed her. He was about to be let out on parole after serving his sentence. He was going to be let loose. But the press found out that he'd been sending these really threatening letters to the mother of his wife's sister, who was taking care of his children. The children of the wife he murdered. Manslaughtered. And what New South Wales Parliament did, they reacted to this in what was, in hindsight, a pretty silly way. They passed a law called the Community Protection Act. The Community Protection Act was called the Community Protection Act, but it only really had one sentence, one section, which was this law means that Gregory Wayne Cable is to be kept in prison. Okay, it had two sections. One, Gregory Wayne Cable is to be kept in prison. Two is a definition. Gregory Wayne Cable is the guy who killed his wife, and blah 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 blah. Explaining who he is, because you wouldn't want to be just some other Gregory Wayne Cable and go, "Hey, that's bullshit. What have you been kept in prison? I didn't do anything." So that in that case, they passed an entire law just to keep him in jail. Now he rightly appealed that decision to pass that law, and he won, and he's out now. And if he's around, I hope he doesn't come and see me, because he probably wouldn't be very happy with all that. But yeah, I mean, to pass an entire law just to keep someone in jail, it turned out that it was unconstitutional. So let's move on to this guy. That's Robert John Farden. The case of Farden and the Attorney General of Queensland. The Queensland government worked out from the New South Wales case. So New South Wales case, the Cable case, was 1995. Later on, the Queensland government wanted to do basically the same thing. So they went through the decision that the Community Protection Act was unconstitutional, and they worked out why it was. It was because it was saying that a particular person was to be kept in jail. Now, you can't do that, because that means that Parliament is taking over the role of the courts, right? So, separation of powers and all that, yeah. So what Queensland did is they said, no, you know what? What we'll do is we'll pass a law that allows a type of person, a particular class of person, to be kept in jail. That particular class at the time really only had one person in it, and that was Robert John Farden. Yeah. So if you think about, if they said, okay, well, we want to pass a law to keep this guy in jail, but we can't say his name, so let's just describe him. Okay, he's this tall, and he's got a big bushy beard, and he's got that haircut, and they could have just described him like that. But instead, they said, anyone who has been convicted of, the serious sexual offences, blah blah blah. So they passed a law called the Dangerous Prisoners Sexual Offenders Act, and Robert John Farden was in that category. So they kept him in jail. The law was found to be lawful because it wasn't just made for one person, and he's still in jail now. He almost got released in 2013, and people freaked out about it with good reason, because he's mad as a cut snake. But he's still in jail now after all those years. The New South Wales government then copied the Queensland government. So New South Wales messed up; they didn't make the law properly. So Queensland did it right, and it's still there now. So then New South Wales copied Queensland, and they made a crime called the Crimes Serious Sex Offenders Act, which is now being changed to the Crimes High Risk Offenders Act, which we'll look at in a second. But the Crimes Serious Sex Offenders Act, and the guy there, Mr. Tillman, was heavily criticised. By some parts of the media. Some parts of the media said, no, this is great. We should keep him in jail forever if we're allowed to, and the law does allow that. At the time, Justice Michael Kirby, the guy on the right-hand side there, he was in the High Court, he said, look, this is ridiculous. He actually, in the Tillman case, he said, no, this is wrong, and he wouldn't go along with the other judges in allowing this law to remain. Because he said, in Australia, such punishment, like, keeping someone in jail forever, theoretically, is not available for crimes that are feared, anticipated, or predicted to occur in the future, on evidence that is notoriously unreliable and otherwise would be inadmissible, and by people who do not have the gift of prophecy. Amen, Justice Kirby. That's exactly right. But we're not going to get rid of it. But this is absolutely right. We can't just say we think someone is going to commit a crime in the future, so we are going to keep them in jail now. You can't just make that assessment. Although we do make that assessment when it comes to bail, we do assume that we know whether someone has already committed a crime and that they will commit a crime sometime before their trial, or whatever's going to happen. It's a prophecy. Like we're thinking that these things are going to happen, and they may not, but we seem to be fairly happy with it. But just like a lot of laws that are passed, say for terrorists, will then get moved from terrorists to bikers to other categories of people. The law doesn't just apply to sex offenders anymore. We passed this Serious Sex Offenders Act because we don't want sex offenders anywhere near us. We want them to stay in jail. But some people worked out straight away, wait a second, okay, but you're setting this precedent for the future that maybe we don't like this type of person or that type of offender or someone who's done that. Why don't we just let everyone be kept in jail forever? Yeah, and it has spread. It has moved on. Like most of the changes that get made for a special case, the government will often expand the law to include other offenders, and there's very little to stop that from happening, right? And prisoners will eventually be regularly kept in jail after their entire sentence on the whim of someone, whoever it may be, who may not like the idea of them getting released. And that's really not going to help anyone, really, except us feel better and sleep better at night. But it's not really a civilized kind of thing to do. So what they did is the original act was the Crime Serious Sex Offenders Act 2006. In 2013, they passed the Crime Serious Sex Offenders Amendment Act of 2013. And you can see it's much shorter. You've only got a couple of bits there, right? And now what it's called, they've stayed with the 2006. So they're kind of pretending that the 2000 amendment didn't really happen. Yeah, wink, wink. Hey, and now they've just changed the name of it to the Crimes High Risk Offenders Act of 2006. And this is terrible. Like this Crimes High Risk Offenders Act it's disgusting. I mean, the way that it works, and you can see that they've even though it was changed in 2013, they should have created a new law. They said, okay, well, we're going to change the name of the law, and we're going to keep the year, so it's like it never happened. And that in itself is annoying, but it's not that bad. It's not like it hasn't been done before. It happened with the De Facto Relationships and Property Relationships Acts. But the Crimes High Risk Offenders Act, it now allows a single judge, not like an unmarried judge, like one judge, to keep someone in jail after being convicted of, say, conspiring to bash someone, without even being 50% sure in his or her head that the person might reoffend. Maybe 10%, 20%, 30%, right? It just needs to be an unacceptable risk. But, an unacceptable risk, that's not 90%, that's not 100% sure, right? It doesn't need to be beyond a reasonable doubt or anything, right? They don't even have to, be flip a coin certain that someone's going to commit another crime. So think about it. I mean, imagine if our whole justice system was like that, right? Imagine if you could just put someone in jail originally, and putting someone in jail and keeping someone in jail, those aren't that different. Like just because they get to stay in the same cell, putting someone in jail and keeping someone in jail, it's the same thing. Like if you put someone in jail for a year, or you keep someone in jail for a year, just because they might happen to be a little bit more used to it than another person is completely wrong, right? Theoretically, if you read the actual law, and I hope that you do, teachers might, but theoretically, it's possible that we could keep a person in jail forever for conspiring to commit a crime when they were a kid. So you could take like a 16, 17-year-old kid who was going to bash someone, like was going to assault someone, who he and his friend said, all right, tomorrow we're going to go bash this guy. Yeah, it's going to be great. It's going to be great. Oh, we'll draw up some plans or something. I don't know, but we'll get busted conspiring to commit a crime. And as long as forever, for the rest of that young person's life, until they're an old person, as long as a judge is always willing to say, yes, you pose an unacceptable risk to the community, that person can stay in there forever. Now, this shouldn't be possible, right? I can just imagine people still being in jail years and years and years. I mean, you could give someone, 1 year in jail or 5 years in jail, and that means life. Yeah. So this is kind of the opposite of our very, very, if you remember right back to the start of this sentencing stuff, this is opposite of that, truth in sentencing thing. It's really lies in sentencing now. Like, we're going to send you to jail for a year. Okay, well, I'll do my year, I'll be good, and I'll do this, and then after a year, I'll get on with my life. No, you won't. You're in jail the rest of your life. Too bad. So it's lies in sentencing. I just came up with it. I'm pretty proud of it, because you're not actually getting told what the sentence is going to be. It's not transparent. It's just in the head of some judge whether they think that you are an unacceptable risk to the community. Sex offenders registration is only obviously for people who've committed a sexual offence against a child or children. And when they get released, they have to register as a sex offender. We have a Child Protection Offenders Registration Act that actually says, it's very strange though, like you don't automatically get registered, but it's a crime not for you to not register. So it's stupid. I don't, like they say, well, you have to do it or you're going to be in trouble. Why don't they just do it for them? I don't know. Anyway, but you have to register as a sex offender. You get put on the Australian National Child Offender Register, the ANCOR, for at least 8 years. If you're an adult, it's different for kids. So this idea of registering who sex offenders are to kind of protect the community, like you don't want them leaving the country, going on a trip to Thailand, or you don't want them going from state to state and finding kids. You want people to know that sort of thing. You want them to be on that register, or go for a job at a school. Although it doesn't actually, it only applies to people who are applying for a school. Then they get like the police check and registration and all that. So as long as you're convicted, while you're still out of school, no. It seems very, very straightforward. It seems like there's not a lot of any justice issues here. But there was a bit of a frightening justice issue. There was a thing, Community Protection of Western Australia. In Western Australia in 2012, they brought in a semi-public list of sex offenders on the internet. So if you moved into an area, you put in your name and your address, and you say, okay, well, this is the area I'm living in with my child. Can you tell me where any sex offenders are so I can avoid them? You can also request to find out whether a specific person is on the list. So if you're going to hire someone, or as a take care of your kids or something like that, or you have suspicions about your neighbor who has really thick glasses and a chubby face and a small chin and bald and is if he looks like the Fat Controller from Thomas the Tank Engine, he's a pedophile. So just use that as a general rule. But how do you know if someone is a sex offender? And how do you know that there are sex offenders in your neighborhood? Now, for parents, as a parent myself, wow, that's a great sentence, isn't it? As a parent myself, I would love to know this information. I'm not, entirely comfortable as a human being, and knowing that these people are not really left to, their rehabilitation. Like, as if you're going to get rehabilitated if you're constantly being known as a sex offender. If you did it once and then you were never going to do it again. I guess this is our judgment saying that, we will, as a society, you will never ever get forgiven. You will never be able to move on. And really, well, why don't we just kill them? Like, it seems cruel and silly to pretend like, oh well, we're going to let you get rehabilitated, and then chase you down and chase you out of town and all that sort of stuff. We should just kill them. It would be the more mature thing to just say, this is what we want to do, so we are going to do it. And you can't hide behind all this. Oh well, no, they were out of jail and they're free to go where they want. It's not true. The controversial issues. First of all, is there a fair balance between the rights of the offender and the society? The victim, if you're balancing the rights of the offender and the victim, who cares? Like, if he has sexually assaulted a child, then that's he can burn in hell. But think of the offenders and society. The victim is never going to have contact with that person again, right? But the rest of society, do we have a right to do that? When Dennis Ferguson, who's now dead, but he was the notorious pedophile, who just always happened to look like he was chasing children, which was had a lot to do with it. If he looked like a normal guy, then yeah, but he always licking his lips and looking at kids. Do we really have a right to just go and stand outside his house and torment him until he leaves and threaten to kill him and all that? Do we have a right to do it? And if we do, then seriously, why don't we just kill them? Right? Why don't we just say, all right, well, that's it. We're going to bring back the death penalty because we're not doing anything good for them. So why don't we just end it? Yeah? But do we balance the rights of offenders in society, which is one of your themes? And there's also a question of whether it's even effective in preventing future sexual assaults. And it's very, very difficult to tell. I mean, there's 2 articles you can read. There's one on Crikey, Moral Panic, does public registration of sex offenders work? And stress on sex offenders increases risk of reoffending, which is what I said before, which is if you keep stressing out sex offenders, if you keep going, pedophile, yeah. If you keep doing that, they're less likely to have any relationships with adults, more likely to have relationships with children, and more likely to have sex with them. So, it doesn't really work. It's kind of, opposite of what you would think is going to happen when you're standing there with your sign or whatever, or your coffin, to get rid of these people. So we need to work out something else to do rather than just making a public list. In California, they had a public list as well, and there was, I think it was a dentist or something, and people went and burned his house down. Because he had this name and the name was on the sex offenders register. But it was the wrong guy. He was just a normal dentist and the sex offender was living somewhere else and he got his house burned down, which is just, that's not cool. If we want people to turn into, vigilantes, then we should be more open about it. We should say, okay, well, like that movie, like The Purge, we should just say, okay, well, go for it. 12 hours a year, go on, go hard, go find all the pedophiles you want, murder them all you want. Deportation is the last one. Non-citizens, so even permanent residents and non-permanent residents who have been in Australia less than 10 years and they were sentenced to more than 12 months imprisonment, they can be deported. I mean, it doesn't always happen, but they can be sent back to their home country. And it's done under the Migration Act. Now, this doesn't seem very controversial because you just go, okay, well, there's a character test to stay in Australia that non-citizens have to follow or have to pass, and you no longer pass that test. If you have been in jail for 2 years in Australia, you're not exactly the type of person that we want to have in Australia. So we're going to send you home under the Migration Act. Now, I think that it's pretty discriminatory. I think that anyone should be able to be deported. So if you're a white person and you've committed crimes, like some of the ones, like if white people had killed Victor Chang, and people say, oh, they got deported. Well, okay, well, let's deport everyone. Why don't we just deport anyone who's a bad person? I don't know, send them somewhere, send them to, I don't know where you could send them, just get them out of here. Why don't we just get them, put them on a boat, and then turn back the boats somewhere? Let's do something like that. Why do we just say, okay, well, if you're an immigrant, then you don't deserve to stay here. But if you're a white Australian, if you came out of a vagina in Australia, then you should be given another chance and another chance and another chance and another chance. The problem here, and the real justice issue here, is that decisions is often made by the immigration minister, and it can't be reversed by the courts. Now that is a significant justice issue. You can the courts are there for just about any type of decision that they can reverse it. The decision to permanently remove someone without giving them a right to appeal, without the decision needing to be based on any facts, is scary. So take the Mohammed Hanif case. He was deported and he had done nothing wrong at all. Right? They spent millions of dollars investigating him. He had no links to terrorism at all. He was just a doctor, and they treated him really, really badly. And in the end, he got deported because he didn't fail because he failed the character test. But it was really just a public opinion test. It had nothing to do with any sort of facts. I mean, the poor guy, he couldn't appeal it. That was just made directly by the immigration minister. Imagine if the minister for all immigration in the country told you get out, and so he was compensated after that. But that'd be horrible. Anything that can't be reversed by the courts is scary. Anything you can't appeal is scary. Anything where the immigration minister is not a judge, the immigration minister is not basing things on facts and having to release a decision and being able to have that decision appealed. He could just do it based on, I don't like Indians, if he really wants to, which may be the case with the immigration minister. Recent big cases as well, other big cases, you got the Chun Ti Lim and Chu Sang Liu, who were convicted of murdering Victor Chang. They served around 20 years each, and they were deported straight away. And people got upset about that because they're like, oh, now they're just hanging out on a beach. But they're old men, so it's not really an issue. And we're not paying for them to be in our prisons anymore. And Mohammed Hanif, who turned out he hadn't committed any crime, but he had his visa cancelled anyway, so he was basically deported for not committing any crime. So these are the cases that you would have to write.